My colleagues to ensure that our hands are not tied by this legislation and to take actions to lower gas prices. I think we can improve this bill, and I think this amendment will do that, and I reserve the balance of my time.
Gentleman reserves. What is the purpose for the gentleman from Texas rise?
I rise in opposition to this amendment.
Gentleman's recognized for 5 minutes.
Thank you. I rise in opposition to this amendment, which would provide an exception for regulations that attempt to manipulate the price of oil, gas, and other fuels. As I was listening to my colleague from across the aisle, I was struck by the fact that he didn't actually mention any possible regulations that could do that. I also would like to point out that our hands as Congress are not tied. This bill ties the hands of regulators. If he is able to come up with a good idea to lower fuel prices, he can bring it to this Congress, we can pass it, the Senate can pass it, and the President can sign it just the way the Founding Fathers intended. Just to be clear, I also want to point out that nothing in H.R. 4078 prevents the administration from taking any number of actions that would increase the supply of domestic oil and gas and lower the price of gasoline at the pump. The passage of this amendment, however, would do nothing to lower the price at the pump. Now, I realize this amendment seems to preserve the option to impose price controls. That's the only thing I could think of they could do. We learned back in the 1970s that price control does nothing but lead to shortage and lines at the gasoline pump. There's absolutely no reason we need to return to the failed policies of the Carter administration. Now, if the current administration were truly interested in providing relief at the pump, there are any number of actions they could do to increase the supply of oil and gasoline and lower the price at the pump. But the Obama administration's done little to tap into vast domestic resources that would increase the supply of American oil. Rather, under President Obama, permitting and leasing on federal land is actually down. Alas, the President has also vetoed the Keystone, or opposed to the Keystone pipeline, which would have connected not only Canadian oil to refineries in the South, but would have also have connected the new finds in North Dakota and the Bakken shale sands. You know, Canadian sands production is expected to double to 3 million barrels a day between 2010 and 2020, and domestic oil production will increase by as much as 20%. The lack of a Keystone XL-like pipeline means slower, less reliable, and less safe forms of transportation that will continue to necessitating transporting domestic oil from North Dakota by much more expensive and much less safe means of truck and rail rather than pipelines. You know, lowering the cost of that transportation would lower the cost of that crude oil and would lower the cost of gasoline at the pump. As a matter of fact, a barrel of North Dakota sweet sells for $62. That's lower than the international price of oil, predominantly because the additional transportation costs necessary to bring it down to be refined in the refineries that are currently set up in this country. If this Bakken oil were made available to the rest of the country, we would see an economic boom. We would see lower prices for gasoline at the pump. We would see more jobs in America. The East Coast in particular needs this oil and this gas made available to bring costs down. You know, Bakken may lead to some price relief there, but it will also open up Canadian oil. We talk about energy independence, but realistically, North America is the energy unit that we should be looking at for providing our source. As we tap resources throughout the United States, Canada, and Mexico, we are going to be able to become energy independent much more rapidly than anyone ever thought as these new technologies develop to let us reach oil and gas deposits that we never, even 10 years ago, thought was possible. I was talking to a geologist just recently when I attended a field hearing in North Dakota, and he told me when he was in school, they always considered shale to be the source and would never be able to tap it. But technology has proved that wrong. And in fact, even with our current technology, we're only getting a small percentage of the actual oil trapped in that shale. I am confident that as our technology develops, that is going to become more and more available. And this is going to take care of it. But what we know is what's running up the price of oil and gas is excessive government regulation. And if we can put a hold on government regulation so our businesses can know what they have to do to comply with those regulations and not have the goalpost moved in the middle of the game, we'll have new refining infrastructure built, we'll have new factories built, we'll have new jobs created, and we will get to an unemployment rate of 6% a whole lot faster, I think, than anybody is predicting. This bill is a rational step to put the brakes on an oppressive government that is stifling job creation, and carving holes in it and creating loopholes like this amendment would do only weakens that and will slow our path to recovery. So I urge my colleagues to defeat this amendment.
Gentleman's time has expired. The gentleman from Iowa.
Yeah, Madam Speaker, how much time is remaining on my side?
A minute and a half remaining.
Thank you, Madam Speaker. I don't know where to begin. I don't have enough time to respond to everything that was said on the other side by my colleague on the other side of the aisle. What I will say at the outset is that this has nothing to do with the Carter administration. It has nothing to do with any previous regulations. It has nothing to do with cost control. This is a very simple amendment. I think if one reads the amendment, you will find that there's absolutely nothing in the amendment that is feared by the gentleman from the other side of the aisle. It's that simple. In fact, it's this kind of debate, if we want to call it that, that is something that's very upsetting to the American people at this time and something I hear in Iowa all the time. We've got to have a rational debate. We've got to have a debate that's based on facts. There's nothing in this amendment whatsoever that the gentleman referred to. And in fact, the amendment itself, because it is so simple and because it is open-ended, would allow for many of the very same things that the gentleman on the other side of the aisle suggests that we ought to do and that I may very well be open to doing myself. I think that's what's important about this amendment. It's simple. It's open. In fact, it allows the very kinds of things that he mentioned to go forward if, in fact, this amendment is adopted. I think this amendment would vastly improve the underlying bill along the lines that the gentleman himself argued. With that, I yield back the rest of my time. Thank you.
Gentleman yields back the time. Questions on the amendment offered by the gentleman from Iowa. Those in favor say aye. Aye. Those opposed say no. No. In the opinion of the chair, the noes have it. The amendment is not agreed to.
Madam Speaker.
Yes, gentleman from Iowa.
On that, I call for a roll call vote, please.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Iowa will be postponed. It is now in order to consider Amendment Number 8, printed in Part B of House Report 112-616. For what purpose does the gentlewoman from California seek recognition?
Madam Chairwoman, I have an amendment at the desk, Richardson Amendment Number 8, regarding H.R. 4078, the Regulatory Freeze for Jobs Act of 2012.
Okay. The clerk will designate the amendment.
Amendment Number 8, printed in Part B of House Report Number 112-616, offered by Ms. Richardson of California.
Pursuant to House Resolution 738, the gentlewoman from California, Ms. Richardson, and a member opposed, each will control 5 minutes. The chair recognizes the gentlewoman from California.
Thank you, Madam Chairwoman, and I'd also like to extend thanks to Chairman Smith and Ranking Member Conyers for having their hard work brought to fruition here on this legislation. The Richardson Amendment would allow the government to take significant regulatory action if and when the monthly national unemployment rate is above 6%, thereby allowing for the action and proper implementation of the Patient Protection and Affordable Care Act and the health provisions of the Health Care and Education Reconciliation Act of 2010. The sponsors of H.R. 4078 suggest that the legislation will promote job growth. I argue that the Affordable Care Act, when fully implemented, will promote job growth, support economic growth, and spur a deficient reduction in our economy in terms of the deficit that we currently are experiencing. My amendment is intended to ensure that the adequate health care through the Affordable Care Act can be fully implemented. Because so many Americans rely upon their employers to have access to health care, high levels of unemployment can leave many of our U.S. citizens uninsured and underinsured. When the monthly unemployment rate is above 6%, as this nation has unfortunately incurred for approximately 2 years now, that is the very time, I would argue, that our government was created to assist the U.S. citizens and all those who obviously need health care. A strong economy needs healthy workers. There is a common and persistent misconception that the Patient Protection and Affordable Care Act will pose an undue burden on small businesses and limit job creation, but this is absolutely untrue. Rather, the Affordable Health Care Act offers $40 billion in tax credits for small businesses. It helps to pay employee health insurance coverage, and in 2011 this tax credit was used to pay for coverage for over 2 million uninsured Americans. In my home district, the 37th Congressional District of California, 510 small businesses have already received this tax credit to maintain or expand their health insurance coverage for their employees. The Affordable Care Act also establishes health insurance exchanges where small business owners and employees can pool their buying power together to shop for affordable plans. Beginning in 2014, all the plans offered in these exchanges will have guaranteed sets of minimum benefits to ensure that small businesses are not faced with gaps in coverage or fine print restrictions documented problems that have plagued recipients in the past. Despite the unfounded claims that this bill will raise taxes for everyday Americans, the Affordable Care Act will bring significant and immediate savings to the middle class at this time when we need it most. With that, I'd reserve the balance of my time.
Lady reserves the balance of the time. What does the gentleman from Arkansas rise?
I rise in opposition to the amendment.
The gentleman has 5 minutes.
Thank you, Madam Chair. This amendment would exempt regulations to implement Obamacare, the President's health care law, from the regulatory freeze. Fear and uncertainty among job creators of the coming regulatory tidal wave to implement Obamacare is certainly holding back our economic recovery. The Congressional Budget Office projects that Obamacare will cost over $1.1 trillion. For American small businesses already struggling to stay afloat, this is a staggering burden. And if you want to know what small businesses think about the bill that is before us, I will tell you that in Arkansas, they tell me they support it, and they certainly do not support Obamacare. I would also point out, Madam Chair, that the NFIB, the premier small business organization in America, supports the bill. It is estimated that Obamacare will require nearly 160 new boards, bureaus, bureaucracies, and commissions. Overall, the federal government will issue roughly 10,000 pages of new regulations to implement the so-called health care reform. Yet this amendment would exempt these regulations from Title I of the Regulatory Freeze for Jobs Act. At a time when we should be working to repeal Obamacare and replace it with patient-centered health care reform, this amendment simply makes no sense. And I would also point out, Madam Chair, that if there are regulations that the Obama administration wants to see proceed through the process, well, they can certainly send them to Congress and see if we will approve them. We can take a look at them, see if they make sense, see if they do what they intend, and see if it's right for the country. For these reasons, I oppose this amendment. I reserve the balance of my time.
Gentleman reserves.
Madam Chair, how much time do I
California
have remaining?
You have 2 minutes and 15 seconds remaining.
Okay. Madam Chairwoman, I'm convinced that President Obama does care. But today I'm here to talk about the Patient Protection and Affordable Care Act. And regarding that act, I think it's important to note that this amendment is not simply a blanket exemption, but rather it deals with when unemployment exceeds 6%, which for those American people, that many of which I represent, who have struggled to no fault of their own to be able to gain employment, this is a significant exemption that's needed. Madam Chairwoman, when we look at the implementation of the Patient Protection and Affordable Care Act, it passed this body in Congress, it passed the body in the Senate, it was signed into law, and now it's been upheld in the Supreme Court of the United States. Healthcare reform is finally here to stay, and the time has come for us to commit ourselves and our attention and our efforts in this Congress to wholeheartedly support its enactment, and where changes and revisions and improvements need to be made, we have an opportunity to do so. The Richardson Amendment I bring forward today does not obligate additional funds to address health care reform, but it would simply give the federal government the freedom that we all believe in to pursue all available options in the future, especially in the greatest times of need. My amendment ensures that the Patient Protection and Affordable Care Act is implemented without adding time and cost-consuming procedural burdens. I urge my colleagues to join me in supporting the Richardson Amendment No. 8 and to reaffirm this nation's commitment to provide the basic necessity. Certainly, I think that equates to the level of the right to a pursuit of happiness, of which this American country was built upon. With that, I yield back the balance of my time.
Gentleman yields back. Gentleman from Arkansas is recognized.
I yield back.
Gentleman yields back. The question is on the amendment offered by the gentlewoman from California. Those in favor say aye. Those opposed say no. In the opinion of the chair, the noes have it by one vote. The amendment is not agreed to.
Madam Chair, I ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by a gentlewoman from California will be postponed. It is now in order to consider Amendment Number 9, printed in Part B of House Report 112-616. For what purpose does the gentleman from California seek recognition?
Madam Chair, I have an amendment at the desk, the Richardson Amendment No. 10 regarding H.R. 4078, the Regulatory Freeze for Jobs Act of 2012.
The clerk will designate the amendment.
Amendment Number 9, printed in Part B of House Report Number 112-616, offered by Ms. Richardson of California.
Pursuant to House Resolution 738, the gentlewoman from California, Ms. Richardson, and a member opposed each will control 5 minutes. The chair recognizes the gentlewoman from California.
Madam Chairwoman, the Richardson Amendment simply improves the bill by allowing for necessary regulations to be promulgated when the monthly national unemployment rate is above 6% in order to protect consumers against unintended consequences that they might suffer under the Fair Credit Reporting Act. This amendment promotes job growth by ensuring small businesses have fair and accurate credit scores to obtain competitive interest loans. This amendment enables the appropriate federal agencies, such as the Federal Reserve, the Federal Trade Commission, and the Consumer Financial Protection Bureau, to issue regulations necessary to protect consumers and to promote small businesses. The Fair Credit Reporting Act, also known as FCRA, is an important piece of legislation that protects the accuracy, fairness, and the privacy of information collected at credit bureaus. It gives consumers the right to view and to challenge the information in their respective credit reports. Although this legislation was originally passed well over 40 years ago, this issue has remained in the forefront of public consciousness, and in 2003 we had provisions that were added to deal with identity theft. The Fair Credit Reporting Act requires the consumer reporting agencies, also known as CRAs, to ensure that they provide accurate, up-to-date information and remove negative information after 10 years. These requirements mandated by the Fair Credit Reporting Act provide entrepreneurs with fair credit scores and enable them to seek competitive loans to start or expand small businesses. There are 28.6 million small businesses in the United States, and small businesses create 2 out of every 3 jobs in this country. In the state of California that I represent, small businesses employ more than 50% of the state's 16 million workers and represent 90% of the job growth for higher income. With that, Madam Chair, I reserve the balance of my time.
The gentlewoman reserves. For what purpose does the gentleman from North Carolina seek recognition?
I rise in opposition.
Without objection, the gentleman is recognized for 5 minutes.
I yield myself such time as I may consume. I would say to the House, and Madam Chair, I would say to my colleagues that the Fair Credit Reporting Act should not be singled out for special treatment. This bill is about creating jobs. And the American people know, as we know, and as rational people looking at the process of regulation know, that higher regulation out of Washington means lower job growth. In particular, what this amendment would do is further constrict access to credit. Furthermore, this bill does not inhibit any individual from getting their free credit report or from having access to their credit report. What this bill, however, prevents is an agency like the CFPB, which is a very powerful agency with an unconfirmed director The President went around the process the Senate has outlined for Senate confirmation. Very controversial appointment. They've taken these powers, and they can write very costly, very expensive rules. Those rules, those costly rules, inhibit credit opportunity for Americans if not done correctly. And we've seen some actions already out of this agency that raise great concerns that it's going to be very costly to small banks and to small businesses. So let's avoid that. Let's reject this amendment. Let's create jobs by passing this bill. And I retain the balance of my time.
The gentleman reserves. The gentlewoman is recognized.
Madam Chair, how much time do I have remaining?
3 minutes remaining. You have 3 minutes remaining.
Madam Chair, in relation to the comments that have been made, I'd like to speak to why the Fair Credit Reporting agencies would be exempted in this particular amendment. You know, I think when you consider that we're national representatives, and rational legislators do know, I would say, and I think small business owners are aware, that without capital, without the ability to have appropriate credit scores, and not to be able to extend that, to be able to get appropriate capital to have your business to be successful, there are no jobs. There is no thriving economy. And that's why, in fact, this agency should be exempted. The statistics are clear. Small businesses are the key to our economic recovery and our continued growth. Relieving the financial burdens of small businesses stabilizes the uncertainty and encourages critical job growth. Entrepreneurs and small businesses are the engines of innovation and economic growth, and the small businesses in my district are at the forefront of that innovation. It would be wrong and counterproductive to limit the federal government's ability to support small businesses when they need it most. I urge my colleagues to join me in supporting the Richardson Amendment number 10 and reaffirming our commitment, this nation's commitment, that when businesses need the assistance, when they in fact can qualify for the assistance, that improper reporting or old reporting certainly shouldn't hinder their ability to have that vibrant business. With that, I yield back the balance of my time.
Gentlewoman yields back. Gentleman from North Carolina.
Thank you, Madam Chair. I would say in closing, the Fair Credit Reporting Act should not be singled out for special treatment, nor should the Consumer Financial Protection Bureau be singled out for special treatment. We should not treat the CFPB rulemaking powers differently than any other federal agency dealt with under this legislation before us. Now, let me also say to my colleagues, it's very important to note that law enforcement actions will continue. Bad actors can continue to be rooted out, regardless of this legislation. And that power is still given to the CFPB and other law enforcing agencies across the government. And furthermore, consumers will continue to have access to their credit reports, and this amendment doesn't address a consumer's ability to get that credit report. Furthermore, let's create jobs by eliminating regulations that inhibit job growth. Let's roll back this uncertainty, give the American people a level of certainty and some expectation of the regulatory framework they have to work under. That's the way we help small businesses be able to take that risk, be able to get that access to credit so they can create jobs and maybe even keep the doors open and the lights on. And with that, I urge my colleagues to reject this amendment and pass the underlying bill. And I yield back the balance of my time.
Gentleman yields back. The question is on the amendment offered by the gentlewoman from California. Those in favor say aye. Aye. Those opposed say no. No. In the opinion of the chair, the noes have it. This amendment is not agreed to.
Madam Chair, I ask for a recorded vote.
Okay. Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentlewoman from California will be postponed. It is now in order to consider Amendment number 10, printed in Part B of House Report 112-616. For what purpose does the gentleman from Virginia seek recognition?
Madam Chairman, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 10, printed in Part B of House Report number 112-616, offered by Mr. Connolly of Virginia.
Pursuant to House Resolution 738, the gentleman from Virginia, Mr. Connolly, and a member opposed each will control 5 minutes. The chair recognizes the gentleman from Virginia.
Thank you, Madam Chairman. My simple amendment would clarify the congressional procedure for acting on the President's written congressional waiver requests as provided for in the bill. Based on their remarks today, it appears my friends on the other side of the aisle view the availability of congressional waivers as sufficient to ensure common sense, popular safeguards such as rules benefiting veterans with catastrophic injuries, assisting students with loan debt, or providing families peace of mind that the peanut butter their children eat will not poison them. So they're not blocked by this bill's arbitrary across-the-board moratorium on significant rulemaking actions because there's a waiver provision. Yet for all of this emphasis on the importance of these congressional waivers, this bill, H.R. 4078, only provides vague, unclear guidance concerning how such action would proceed on the President's waiver request. H.R. 4078 only specifies that Congress shall give each submission by the President, quote, expeditious consideration, and take, quote, appropriate legislative action without defining these terms in statute. Anyone who's watched this Congress, this 112th Congress here in the House, knows that they shouldn't put undue faith in terms like expeditious consideration. Despite Republican claims to the contrary notwithstanding, as currently written, the congressional waiver provisions appear designed to spur effective talking points, not exactly an efficient process for considering presidential submissions. My amendment, my simple amendment, ensures that if the President requests a necessary and urgent waiver, such as the flexibility for the Department of Labor to issue a rule protecting coal miners from black lung disease, expeditious consideration shall not take longer than 1 week. This simple amendment takes no position on the wisdom of the given waiver request. It simply requires that Congress, whether it decides to approve or disapprove of a President's request, do so within 7 days. As the numerous amendments filed by my colleagues demonstrate, the majority of the President's waiver requests will address non-controversial yet critically important rules that protect our nation's veterans, families, workers, environment, and economy. In supporting this perfecting amendment, members will ensure that no American is endangered because of congressional inaction. I reserve the balance of my time.
The gentleman reserves. For what purpose does the gentleman from Arkansas seek recognition?
I rise in opposition to the amendment.
The gentleman is recognized for 5 minutes.
Thank you, Madam Chair. As I have said with regard to the other amendments that we have discussed here tonight, Madam Chair, there's an exemption in the there are several exemptions in the bill, and there's also the waiver, as the gentleman from Virginia has discussed. Now, before I get to the waiver, I'd like to point out that unless I'm missing something, I think that the safety of peanut butter that I and my 2-year-old and my 4-year-old eat, I like crunchy, they like creamy, I think it's already regulated. And if it's not, we certainly make provision for that to happen. I, like the gentleman from Virginia, want to make sure people are protected. I happen to also be a veteran, and I certainly want to see veterans taken care of. I want to make it clear that our bill does not go back and repeal regulations that are finalized and in place. What it does is it says, let's take a deep breath, let's have a timeout, let's allow the many small businesses and other job creators in this country some opportunity to catch up. We've heard a lot about small businesses tonight, and I would point out once again that the premier small business organization in this country is the NFIB, and they support the bill. Now, with regard to the gentleman from Virginia's amendment, the Regulatory Freeze for Jobs Act will put a moratorium on unnecessary regulations that cost the economy $100 million or more until the economy recovers. Even the administration admits that regulations can kill jobs and hinder economic growth. Although this doesn't seem to have prevented them from issuing more and more of these most costly regulations. Title I of the bill is carefully drafted to allow the President to issue certain necessary regulations during the moratorium period, such as regulations that implement trade agreements, for national security, for criminal and civil rights laws, the enforcement of those laws, and for an imminent threat to health or safety or other emergency. For any necessary regulation not covered by one of these exceptions, we have the congressional waiver that the gentleman from Virginia referred to. Under it, the President can ask permission for Congress to make the regulation, to approve it. This is entirely appropriate since the Constitution vests in Congress all legislative powers. But this amendment could totally undermine the moratorium by allowing the President to swamp Congress with waiver requests. If Congress doesn't act on each request within 7 days, and the amendment doesn't specify whether this is calendar, session, or legislative days, then the waiver is deemed granted. With its track record of dramatically increasing the regulatory burden on the economy, this administration has shown that it cannot be trusted not to abuse the process this amendment would create. For these reasons, I oppose the amendment. I reserve the balance of my time.
The gentleman reserves.
for question?
The gentleman reserves. Gentleman from
May I inquire of the Chair
Virginia.
how
Gentleman's
much
recognized.
time is left on this side?
You have 2.5 minutes remaining.
I would yield 2 minutes to the distinguished ranking member of the Oversight and Government Reform Committee, Mr. Cummings of Maryland.
Thank you very much.
Gentleman from Maryland is recognized for 2 minutes.
Thank you very much, Madam Chair. I support the amendment offered by Mr. Connolly. The congressional waiver provision in this underlying bill is a farce. It requires the President to ask Congress's permission to issue a regulation and then wait for both houses of Congress to approve the waiver. Give me a break. That could take months in the best case, but the more likely scenario is that it would never happen at all, and everybody knows that. By adopting this amendment, we can ensure that the President can truly issue regulations when needed. Under this amendment, the waiver provision in the underlying bill will be changed so that if Congress doesn't act within 7 days on a waiver request submitted to it by the President, the waiver would be granted. Let me be clear. Under this amendment, Congress would still have the opportunity to object to a regulation when necessary. This amendment simply ensures that Congress's failure to act doesn't prevent the President from issuing needed regulations. The majority claims that the congressional waiver provision in the underlying bill will ensure that the President can still issue important regulations. If the majority really intends to give the President that flexibility, they will adopt this amendment. I hope my colleagues will join me in supporting this amendment, and with that, I yield back.
Gentleman yields back. Gentleman from Arkansas.
I would just point out, Madam Chair, that the part of the bill that the gentleman from Maryland calls a farce, the Founding Fathers might refer to as balance of powers. And that's what we're trying to do here, allow Congress to share in the process since we are the source of all legislative power. That is just another reason that I oppose this amendment, and I reserve the balance of my time.
On reserves, gentleman from Virginia.
Chris, I know my friend from Arkansas knows his history. That was the whole battle of Federalists versus Anti-Federalists, and the Federalists won out. That's how the Constitution of the United States got adopted, a more powerful government to help the union of the states. Madam Chairman, I close by simply noting the irony of opposing any kind of finite time limit. The very organization cited by my friend from Arkansas, NFIB, screams the loudest about uncertainty, and yet here we are going to have expeditious consideration that could take weeks or months here in this body, and we're not going to put a finite time limit to give them the predictability and the certainty they say they want. I think it's the minimum required in this legislation if we really mean to effectuate change, and I yield back.
Gentleman yields back. Gentleman from Arkansas.
I yield back.
Gentleman yields back. The question is on the amendment offered by the gentleman from Virginia. Those in favor say aye. Aye. Those opposed say no. In the opinion of the chair, the noes have it.
Madam Chairman.
Yes.
On that matter, I would request a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Virginia will be postponed. It is now in order to consider Amendment Number 11, printed in Part B of House Report 112-616. For what purpose does the gentleman from Florida seek recognition?
Thank you, Madam Chairman. I have an amendment at the desk. It's number 11.
Okay. The clerk will designate the amendment.
Amendment number 11, printed in Part B of House Report number 112-616, offered by Mr. Posey of Florida.
Pursuant to House Resolution 738, the gentleman from Florida, Mr. Posey, and a member opposed will control 5 minutes. The chair recognizes the gentleman from Florida.
Thank you, Madam Chair. I'd like to yield myself as much time as I may consume.
The gentleman may proceed.
Thank you. Madam Chair, today in Washington, bureaucrats are able to craft and enforce rules that cost our economy billions of dollars while remaining aloof of the consequences of their actions. There remains a disconnect between those who write these rules in the comfort of the Beltway, generating reams of red tape, and the actions taken by the courts or Congress to delay or roll back those same rules. When a regulator has overreached, they have wrongfully robbed American citizens of their benefits, of their labor, and their means of productivity. Today, there is really no penalty for those who overreach. I believe regulators should be more prudent and measured when drafting and issuing rules and regulations. My amendment simply calls agency bureaucrats to account when they exceed their delegated authority. Section 104 of the underlying bill permits the court to award reasonable attorney fees and costs to a small business when they prevailed in a suit against an agency that has exceeded their statutory regulatory authority. My amendment takes us a step further by requiring any attorney's fees and costs be paid out of the administrative budget of the particular office that's found to have exceeded that authority. I believe this will give regulators greater pause before they issue regulations and will cause them to double-check to make sure they're on solid ground. When an agency overreaches, what they are fundamentally doing is denying an American citizen their right to pursue opportunity, create jobs, or otherwise enjoy the benefits of their labors. In a sense, they're basically robbing someone of their opportunity. Outside of the regulatory environment, when someone takes property that belongs to someone else, there's criminal sanctions if we catch them doing it. In the regulatory environment, however, the best that an American citizen can expect from the federal government is, "I'm sorry," and that's at best. We changed that in this bill, and with the adoption of my amendment, we change for that particular regulators, those particular regulators that exceed their authority. If adopted, this amendment will give more certainty to the regulatory process, and it will ensure regulators are more prudent when drafting regulations. We make sure that any damages aren't paid out of the agency slush fund, but rather out of the administrative budget of the offending office. That brings personal and government accountability to the regulatory process, something that's desperately needed. Now, they will have some skin in the game, so to speak. I urge my colleagues to support this good amendment, and I reserve the balance of my time.
Gentleman reserves. Who seeks time in opposition?
I do.
Gentleman is recognized for 5 minutes.
Thank you. I yield myself for such time as I may consume. Madam Speaker, I strongly oppose the Posey Amendment because it makes even worse an already deeply problematic provision. Under Title I of this bill, a court is required to award attorney's fees and costs to a, quote, substantially prevailing, unquote, small business in any civil action to challenge an agency's compliance with the moratorium. That provision further states that a small business can be substantially prevailing in the meaning of the bill, even in the absence of a final judgment in its favor, quote, if the agency that took the significant regulatory action changes its position after the civil action is filed, close quote. There are two problems with this. First, it doesn't matter if the agency's change in position had absolutely nothing to do with the civil action. A court would still have to award attorney's fees to a small business that challenges an agency's compliance with the moratorium in court, even if the change in policy had nothing to do with the lawsuit. Bad as this provision already is, the Posey Amendment makes it even worse by requiring that an award of attorney's fees and costs be taken out of the defendant agency's budget. Agencies are already straining under diminishing financial and staff resources, thanks in no small part to the budget priorities of this House during this Congress. Further debilitating agencies by taking fee awards out of their budgets, even under circumstances when their change in position had nothing to do with the underlying lawsuit, further damages agencies' ability to do what Congress has tasked them with doing, namely protecting public health and safety. So in other words, what this amendment says is, if an agency has a regulation which in its judgment it must issue to protect the public health and safety, and a small business sues to stop that, and even if the small business doesn't prevail, if there is any change in the agency's position, and even if that change in position has nothing to do with the subject of the lawsuit by the small business, it must pay attorney's fees, and under this amendment, it must pay attorney's fees out of its own budget. Secondly, and that's dangerous because it will debilitate the agencies that we task with protecting the public health and safety. Second of all, it's self-defeating, because if you're the agency and you know that if you are going to change your position anyway, you're going to have to pay the attorney's fees out of your own budget, better don't change. Fight the lawsuit. Don't give in. Fight the small business because you may win. Well, if you change your position anyway, if you compromise, if you say, you know, they don't have that great a case, but we can accommodate them by making a small change, no, then you've got to pay attorney's fees out of your own budget. So don't accommodate them. Don't compromise with them. Don't make the change. Fight them to the bitter end. That doesn't help the small business, and it certainly doesn't help the American people who need these agencies to police the marketplace and to protect the public health and safety. So it defeats its own purpose in addition to period. It's just wrong on so many levels. I reserve the balance of my time.
Gentleman reserves. Gentleman from Florida.
Inquiry, how much time we have?
You have 2 minutes remaining.
I'd like to yield 1 minute to the gentleman from Arkansas.
Gentleman from Arkansas is recognized for 1 minute.
Thank you, Madam Chair. I rise in support of this amendment. If an agency improperly makes a regulation during the moratorium period, as written, the Freeze Act would allow a small business that successfully challenges the action to collect attorney's fees. The gentleman from Florida's amendment would strengthen this provision by ensuring that any attorney's fees awarded under Title I come out of the agency's budget and not from the general federal treasury through, for example, the judgment fund. If an office or agency defies the law and tries to make a regulation that should be subject to the Freeze Act, then that particular office or agency should bear the consequences of forcing a small business to go to court to vindicate its rights. For these reasons, I support the amendment.
Gentleman yields back. Gentleman from New York.
How much time do I have?
2 minutes.
Thank you. Madam Chair, I yield myself such time as I may consume.
Gentleman's recognized.
Again, we oppose the bill to start with because we shouldn't have a moratorium on rules that are intended to protect the public health and safety that may be necessary. But second of all, this amendment is self-defeating because even if a small business sues the agency, two things. Number one, let's assume that the agency thinks that the small business's suit has some merit. Not enough to win the case, but some merit. Under this amendment, the agency cannot compromise, cannot say, you know, you're right, we'll make this change, because the moment it makes a change, then even if a minor change, then it is no longer the prevailing party. The small business, under the definition of the bill, is the prevailing party and will get attorney's fees, and the attorney's fees come out of the budget, maybe the small budget of the agency. So rather than yielding in any way, rather than compromising with the small business, fight them. Fight them tooth and nail. That's what this amendment says to the agency. It is on its own terms silly and self-defeating, and I urge its defeat. I yield back.
The gentleman yields back. The gentleman from Florida is recognized.
Let me tell anyone who may not have ever seen a war with an agency over agency rules before, they dig in and they fight to the death anyway, whether it's coming out of their budget or not. I've seen them lose at 3 levels with a private citizen and go after them yet a 4th time because their pockets are bottomless and they hope they could break back the citizen like that. You know, what makes this country unique is we believe we get our rights from God. We believe in inalienable human rights here. And we give rights to government. Government doesn't give us rights. We give rights to our government. And we're charged with administering the rights that were given to our government here in Congress. And we give the administration, we give the agencies rights to write rules, specific rules. We don't allow them, without our authority and beyond the scope of their authority, to abuse the citizens, to steal their productivity, the labor, the benefits that they've worked hard for. And that's what the agencies have done. We've asked them not to do it. They've reformed the Administrative Procedures Act a number of times. The agencies just don't get the message. They seem like it's their goal and their destiny to be the boss. Congress is supposed to have dominion over the bureaucrats, and this is one of the ways that we're going to enforce that dominion. We don't let the fox run the hen house.
Gentleman's time has expired. Thank you. The question is on the amendment offered by the gentleman from Florida. Those in favor say aye. Those opposed say no. No. In the opinion of the chair, the noes have it. The amendment is not agreed to.
Did you say the noes have it?
I did. I'm sorry.
I'd like to have a recorded vote.
All right. Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Florida will be postponed. It is now in order to consider Amendment Number 12, printed in Part B of House Report 112-616. For what purpose does the gentleman from New York seek recognition?
Madam Chair, I have an amendment to the desk made in order under the rule.
The clerk will designate the amendment.
Amendment Number 12, printed in Part B of House Report Number 112-616, offered by Mr. Nadler of New York.
Pursuant to House Resolution 738, the gentleman from New York, Mr. Nadler, and a member opposed each will control 5 minutes. The chair recognizes the gentleman from New York.
Thank you, Madam Chair. I yield myself 4.5 minutes.
The gentleman's recognized for 4.5 minutes.
Madam Chair, I rise in support of my amendment, which would exempt rules to protect nuclear power plant safety from Titles 1, 3, and 5 of the bill. It is rare that the premises of an entire week of legislative work on the House floor is wrong. But here we are. We are told this is regulatory week, during which House Republicans are supposedly working to see that the yoke of oppressive government regulation is thrown off and the American entrepreneur is free to grow his or her business and increase jobs. In thinking about this view, I am reminded of a famous line in Shakespeare's Macbeth. It is a tale told by an idiot, full of sound and fury, signifying nothing. We have heard and will continue to hear a lot of sound and fury this week on the House floor. But just like all of the other regulatory bills the House has passed this year, what we pass this week will die in the Senate as well. So all of that talk will signify nothing. Like health care repeal, on which we have taken 33 votes, this too is a tremendous waste of time. More importantly, there is no evidence to support the position that overregulation is a major cause of our slow economic growth and high unemployment rate. According to the Economic Policy Institute, economy-wide studies do not find a significant decline in employment from regulatory policies. The real culprit of our slow growth and high unemployment is reduced aggregate demand. Do not just take my word for it. This is what economists and businesses are saying. The Wall Street Journal surveyed dozens of economists last July and found that, quote, the main reason U.S. companies are reluctant to step up hiring is scant demand, close quote. The National Federation of Independent Business found that when business owners with declining sales were asked the cause, 45% said declining sales. Only 10% said higher taxes and regulations. If all of this is true, why are we here making it harder for the government to enact protective rules and regulations to protect the public health and safety? Bruce Bartlett, a senior policy analyst in the Reagan and George H.W. Bush administration, suggests an answer. He has said that, quote, regulatory uncertainty is a canard invented by Republicans that allows them to use current economic problems to pursue an agenda supported by the business community year in and year out. In other words, it is a simple case of political opportunism, not a serious effort to deal with high unemployment, close quote. Let us look at what the bill that this canard has brought us would do. To me, it seems like Frankenstein. It's put together from various different pieces that do not fit together, and it is very frightening. For example, the underlying bill would block all and any major efforts to protect public health, safety, the environment, and so on, until the unemployment rate falls below the arbitrary figure of 6%. And the bill would impose needless costs on the government and make protecting health and welfare that much more difficult by putting impediments to agreeing to consent decrees and settlements. What all this means is that for the most potentially dangerous industries like nuclear power, the safety of the American public would be put at serious risk by this bill. My amendment would attempt to make this Frankenstein bill slightly less of a horror show by exempting the issue of nuclear power plant safety from 3 sections of the bill. The dangers of nuclear power are well known. One accident could doom millions of people. Because of the almost unimaginable disaster that could happen in a nuclear power plant, regulations to prevent accidents or meltdowns in advance are critically important. The underlying bill would make it harder for the Nuclear Regulatory Commission to adopt such rules or policies, thereby putting millions of lives at risk. hampering the ability of the NRC to require safety measures like those necessary to prevent a meltdown in the event of an earthquake or an act of terrorism could be devastating. My amendment would free the NRC from the burdens of this bill and allow it to promulgate those rules and regulations necessary to protect us from the disaster of a nuclear catastrophe such as those that occurred at Chernobyl in Russia or at Fukushima in Japan. I urge everyone to pass the amendment. To approve the amendment, I reserve the balance of my time.
The gentleman reserves the balance of his time. For what reason does the gentleman from Florida seek recognition?
Madam Speaker, I rise in opposition of the amendment.
The gentleman is recognized for 5 minutes.
Thank you. Madam Speaker, this amendment would unnecessarily exempt regulations from Title I and consent decrees and settlement agreements contained in Title III. Title I already contains adequate exceptions for necessary covered regulations. Agencies do not yet need another loophole to make regulations by consent decree or settlement agreement. As to Title V, the part of the bill that was formerly known as the Responsibly and Professionally Invigorating Development Act, also known as the RAPID Act, this amendment would block needed construction projects from breaking ground. Unemployment is stuck above 8% and millions of Americans are looking for work. The March 2011 Project No Project study identified 351 energy projects, including nuclear projects, that if approved could generate $1.1 trillion in the economy and 1.9 million jobs. I appreciate that the gentleman is concerned about safety of nuclear power. But this act does not require agencies to approve or deny any particular project or permit application. Nor would any agency ever act on a permit application before all the relevant review and analysis has been completed. Rather, the act establishes a reasonable timetable for agencies to follow in conducting the environmental review and making permitting decisions. This will give job creators and investors confidence that the process will not drag on indefinitely. The act is consistent with the administration's own guidance and rhetoric and with the President's Jobs Council's recommendations. It builds upon bipartisan legislation that passed the 109th Congress, which has dramatically reduced the time it takes to prepare environmental impact statements for transportation projects. In short, the road to economic recovery runs through permit streamlining. For these reasons, I oppose the amendment and reserve the balance of my time.
The gentleman reserves the balance of his time. The gentleman from New York.
How much time do I have left?
The gentleman has 1 minute.
Thank you. I yield myself. Madam Chair, first of all, we're dealing with nuclear regulatory authority, with nuclear power plants, so we're not dealing with small businesses. We're dealing with very large businesses. Secondly, we're dealing with permits for construction or modification of a nuclear power plant. Because of the disaster at Fukushima, we learn, hopefully we learn from experience. It may very well be that the Nuclear Regulatory Commission will want to put out new regulations or modify old ones in light of what we have learned, of what the Japanese didn't do right. And this would say that they could not promulgate any such regulation as long as unemployment is above 6%. As long as unemployment is above 6%, we must continue to risk all of our lives. That makes no sense. Second of all, yes, we want to do environmental streamlining. But what this bill says, and this would apply to this too, is that if an environmental impact statement takes longer than a certain number of days, forget about it. But it's the sponsor, not the Nuclear Regulatory Agency, the sponsor that controls the timing of the EIS. So if you've got a terrible project which you know is an environmental disaster, all you have to do under this bill is to slow walk the EIS because you control it, and then you don't have to worry about any environmental consequences. That's backwards, it's upside down, and it risks the public safety. I urge the adoption of this amendment.
The gentleman's time has expired. The gentleman from Florida.
Thank you, Madam Chair. Let's look at this. If the sponsoring agency decides to hold back, and there's a presumption or approval, who better to have the onus of having to prove that it should not be built than those who fail to act, as opposed to those who are ready to act? You know, the one thing that we found out is that the regulatory environment is so burdensome that whatever recovery our country attempts to pursue right now is being strangled. Polls show it. A Gallup poll in February 15th of 2012, among 85% of U.S. small business owners who are not hiring, nearly 46% of these cited being worried about new government regulations. Small business owners cite complying with government regulations as their most important problem. It is overwhelming that we have placed in the hands of bureaucratic agencies unaccountable authority that is strangling the business recovery of this country. This bill, as it is, without this amendment, will allow for the streamlining in 4.5 years of the permitting process, and the permitting process will allow us to invest private capital to create private sector jobs. And with that, I urge opposition of this amendment and yield back the balance of my time.
Gentleman yields back. The question is on the amendment offered by the gentleman from New York. Those in favor say aye. Aye. Those opposed say no. In the opinion of the chair, the noes have it. The amendment is not agreed to. Gentleman from New York.
Call for the ayes and nays.
Yes. Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from New York will be postponed. It is now in order to consider Amendment Number 13, printed in Part B of House Report 112-616. For what reason does the gentleman from West Virginia seek recognition?
Madam Chairman, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment Number 13, printed in Part B of House Report Number 112-616, offered by Mr. McKinley of West Virginia.
Pursuant to House Resolution 738, the gentleman from West Virginia, Mr. McKinley, and a member opposed will each control 5 minutes. The chair recognizes the gentleman from West Virginia.
Thank you, Madam Chairman. I rise today to offer an amendment that will add more clarity, accountability into the regulatory process. Under this bill, Congress will require additional analysis and reporting on all government regulations affecting the economy by $100 million or more annually. This amendment simply reduces this threshold of $100 million to $50 million. In FY 2011, nearly 4,000 rules were published in the Federal Register. Only 83 of these rules were classified as having an annual effect on the economy of $100 million or more. This represents only 2.1% of all the rules published. Thus far in 2012, 2,071 rules have been published, and 51 of these have been projected to have an annual effect on the economy of $100 million or more, equating to just 2.4%. According to the Small Business Administration, the cumulative burden of regulations exceed more than $1 trillion annually on our economy, costing more than $10,000 per household. Regulations are clearly impacting our economy by this astounding $1 trillion each year, and nearly 98% of these rules have virtually no economic analysis or oversight. We have more than 23 million Americans underemployed or unemployed. This political maneuvering and rulemaking has to stop. The American people sent us here to improve the economy, help them get back to work, but not to allow the promulgation of more questionable, job-hindering regulations. When I served in the West Virginia legislature in the 80s and early 90s, no regulations were adopted until the legislature approved them. Not just a few here and there. Every single regulation came before the legislature for approval, significant or otherwise. Not conducting analysis and reports on nearly 98% of all government agencies' proposed regulation confound and confront our job creators with potentially excessive and burdensome rules. Madam Chairman, as a reminder, in 1995, Congress passed the Job Creation and Wage Enhancement Act, which dealt with lowering the regulatory threshold from $100 million to $50 million, just as this amendment would do today. That bill passed the House by a vote of 277 to 141, including many members who are present here today. Madam Chairman, I reserve the balance of my time.
The gentleman reserves the balance of his time. For what reason does the gentleman from Maryland?
I rise to claim time in opposition Madam Chair.
The gentleman is recognized for 5 minutes.
Thank you very much. I yield myself such time as I may consume. I strongly oppose the amendment offered by the gentleman from West Virginia, Mr. McKinley, which would make a very dangerous bill even more devastating to the American people. If implemented, this amendment would broaden the scope of this legislation to impede the issuance of even more rules than are impeded by the underlying bill itself. By lowering the threshold at which a significant regulatory action is measured from rules that have an annual cost to the economy of $100 million or more to just $50 million or more, the legislation would prevent the implementation of important rules whose benefits far outweigh their costs. One of the things that we do not zero in on with regard to this legislation overall, and we saw it in our committee, is the cost-benefit analysis. And I think it's very, very significant when you think about the fact that there are certain rules or regs which save lives, many which protect our constituents with regard to their pocketbooks, all kinds of things. And so just sometimes when you just look at the cost of a business coming in and complaining, as opposed to balancing it with regard to benefits, sometimes I think things get out of balance. The amendment clearly illustrates why Cash Sunshine believes a moratorium on the issuance of regulations is such a bad idea. As he stated at an Oversight Committee hearing last September, and I quote, he said a moratorium would not be a scalpel or a machete. It would be more like a nuclear bomb in the sense that it would prevent regulations that cost very little and have very significant economic or public health benefits. This amendment only increases the size of the bomb we are dropping. Just one example of a pending regulation that would be halted by this amendment is the Securities and Exchange Commission's proposed rule implementing a section of the Dodd-Frank Act to reduce the purchase of, quote, conflict minerals, unquote. Minerals whose sale by combatants in the Democratic Republic of the Congo is known to fund the human rights abuses perpetrated by these combatants. Dodd-Frank requires the SEC to issue a rule directing publicly held companies to disclose whether any of 4 metals, gold, titanium, tungsten, or tin, used in the products they produce came from Central Africa, where trade in these commodities has funded years of civil war. The SEC issued a proposed rule in December 2010, but has delayed finalizing the rule in response to fierce business opposition and business lobbying. This proposed rule is estimated to cost the industry $71 million per year. The benefits of this rule cannot be quantified, simply cannot. By ensuring that publicly traded companies in the United States track the supply chain of minerals and disclose whether their purchases are financing armed groups responsible for committing atrocities, killing people, rapes, hurting people, this proposed rule will save lives and help prevent sexual and gender-based violence. Adopting this amendment would prohibit the issuance of this regulation intended to help quell international violence and help end a humanitarian crisis. We simply cannot put a financial profit, as I said a few minutes ago, above our moral obligation to protect the most vulnerable among us. So, ladies and gentlemen, I urge members to oppose this incredibly dangerous amendment, and I continue to reserve the balance of my time.
The gentleman reserves his time. The gentleman from West Virginia.
Again, Madam Chairman, I just respectfully disagree with